The False Claims Act is a federal statute that allows private citizens to bring suit in the name of the United States government where they have information that the government has been defrauded by a person, corporation, or party. There are approximately 20 some odd states that have analogous statutes called state false claims acts that allow for litigation where similar activity has caused the wrongful expenditure of state funds. What I want to talk to you about today is how one selects an attorney to litigate these cases and how these cases are put together. As a first point, it's essential that anybody approaching a False Claims Act case look at it as if they are putting together a case that will be presented to a jury. Too many lawyers approach litigation by filing a complaint and then say to themselves, you know what, I'll see what comes after. And in today's world of complex litigation, cases are front-loaded. That means you look at how this case will be presented to a jury. You try to gather as much of that information or evidence as quickly as possible and bolt that into a complaint. And the idea is that you get a running start by putting this information together, and then you use the litigation process, including discovery, which includes depositions, interrogatories, and so forth, to flesh out the case. Now, of course, false claims cases are initially filed in the United States District Court or a state court if the case only involves state court claims, and they're filed under seal, which allows the government the opportunity to investigate the case. More specifically, what I want to drill down on is how we deal with evidence in a false claims case. In federal court, there is a body of rules called the Federal Rules of Evidence. And the Federal Rules of Evidence govern what types of evidence are going to be admissible and ultimately presented to a jury. And one of the essential rules that's often overlooked is Rule 401, which is the test for relevant evidence. And evidence is relevant, according to the rule, if it has any tendency to make a fact more or less probable than it would be without the evidence, and the fact is of consequence in determining the action. Now that sounds like it's a bunch of legal wording, but essentially what it says is that any bit of information, any fact that gets you closer, the fact finder closer, to determining an issue in dispute is going to be relevant. And if you read the rule closely, it does not distinguish between what we call circumstantial evidence and direct evidence. Circumstantial evidence is evidence that you have where you argue the inference that an event occurred. Direct evidence is, I saw it happen. So for example, in a circumstantial evidence situation, we may have the ultimate issue of who ate the cookies. And we see, for example, one slide showing that there was a bowl of cookies on the table, another slide showing 10 minutes later there was no bowl of cookies on the table, and a third slide which shows that there was a dog licking his teeth and his face was full of chocolate. And you argue the inference from the circumstantial evidence that in fact the dog ate the chocolate chip cookies. Direct evidence would be a photograph of the dog eating the chocolate chip cookies. What's critically important to understand is that false claims cases are fraud cases. And in fraud cases, we're dealing with a complex array of facts. And often the actors, the defendants, try to put their conduct in such a way that it's hard to piece it together. And so they try not to create too much direct evidence. And so these large cases are built on what we call circumstantial evidence. And the job of a lawyer is to aggregate and piece together the circumstantial evidence, the little itty-bitty building blocks for a piece of litigation. And the only way that you appreciate this really is if you've actually tried a case, presented a case to a jury, presented a case to a judge, because you're understanding what kind of evidence is going to be admissible. So I want to say to you that in selecting a lawyer, it's critically important that you have somebody who has the ability not just to put a cause of action, a case in play, but somebody who appreciates what it takes to take that case from beginning to end, which is trial before a judge and a jury. Thank you, and I hope that helps you with a better understanding of the False Claims Act and how these cases are put together.